So anyway, I was watching RT the other night, and there was a show on there. I think it's called The Big Picture with a guy Tom Hartman, and I was really surprised that he took this position that Marbury v. Madison was wrongly decided. And it's really sort of ironic because that argument, trace back the argument, and you'll understand what I'm getting at. Because if you trace back the argument with banking, it goes back to the landed gentry, the heart, soul, and flesh of feudalism in England. They were opposed to the chartering the Bank of England. In fact, all of the arguments that were used against the First National Bank were lifted from the arguments proposed by the landed gentry. In fact, if you compare the landed gentry and people that were into what was known as the early capitalists that were associated with the Bank of England, it's very similar to Democratic Republicans being on the side of the landed gentry, and also the Federalist Party in the United States having represented commercial interests, Jews primarily. I mean, if you don't allow Jewish people to own land, you can't own land because the landed gentry, the blood thing and everything. What are you going to do in order to survive? You're going to start finding ways of collecting money to buy things with so that you could survive, which is what happened. But I mean, it wasn't just Jewish people. There were all sorts of people that were involved in trade and commerce and things. But that's where those arguments lead back to. And this thing with Marbury v. Madison is also a conservative. It's a states' rights argument. And what it's essentially, the reason it's a states' rights argument and how it's a states' rights argument is because what it deals with is sovereignty. What is the nature of sovereignty in the United States as opposed to what is the nature of sovereignty in England? Well, it's easy. In England at that period of time, it was the crown, whether king, queen, whatever, the monarch was sovereign. And the sovereign could do no wrong. Well, Marbury v. Madison really has nothing to do at all with saying that acts of Congress or acts of the state or whatever are unconstitutional. What it has to do with is it has to do with these things that were known as prerogative writs. And prerogative writs were essentially things that simply occurred by what the role of the monarch was. What did he or she do? What was the nature of their position? Okay, so these writs were essentially just things that they wrote that were orders, like executive orders. And the one that was involved with Marbury v. Madison was mandamus to compel. And essentially what that is it's telling an executive officer to perform some act, which, and this is part of the controversy, this is the way it is nowadays because the conservatives own the court, is a ministerial, it has to be a ministerial task. It has to be something that is specifically their duty and obligation to perform, which they refuse to perform. And what happened in Marbury v. Madison was that John Adams appointed a Federalist as Justice of the Peace for the Capital District. And when Jefferson became elected, it was never known whether Thomas Jefferson told Madison as Secretary of State, okay, just forget about Marbury there. We're putting Democratic Republicans in. We don't want these Federalists in here, so just don't give him, just don't seal his I can't even remember what the hell it was called, certificate of election or something, so that he could take office. So this is essentially what the case was about. The matter was brought by petitioning for mandamus to compel. Now I can't remember, right? It's been a while since I read the case. I can't remember if this was something that the court decided was the proper remedy for this, or whether he actually petitioned for this. I think it was that he petitioned for it. I'm not sure though. But it doesn't have to. The court overturning an act of a state or an act of Congress really has the only similarity between Marbury v. Madison and that is the fact that it dealt with sovereignty. Who is sovereign? Is the President of the United States sovereign? Is Congress sovereign? Because, of course, later in England, after the courts were formed and the prerogative writs went from the king to the courts, farther down the line, you had the Republicans, the guys that burn witches and all of that stuff, cut off the head of the king because he was Roman Catholic, and assumed control of government. And then when the monarchy was restored, you had dual sovereignty. You know, Parliament could do no wrong, the king could do no wrong. But the nature of sovereignty was decided in a case, Chisholm v. Georgia, by our first Chief Justice of the United States, which was John Jay, who was a Federalist. Now, this guy, Hartman, says that John Marshall was a Federalist. I guess he was, but so was James Madison. James Madison was purportedly a Federalist from Virginia, and so was John Marshall from Virginia. And the interesting thing, how this ties all in, is because one of the cases that Marshall argued when he was an attorney, I don't know if he was, I don't think it was when he was Solicitor General. I think it was just when he was an attorney, a private attorney, was he argued on behalf of these debtors that because the United States won the war against Britain and the United States was independent, that these guys didn't have to pay any of their private debts to private creditors in Britain. And Marshall actually argued on their behalf, which was contrary to everything that the Federalist Party stood for. So that whole thing is just, it's just, you know. And the thing with Chisholm v. Georgia, here's one of the things that you want to do. You want to abolish the 11th Amendment. Because these states' rights people, this so-called libertarian, this Ron Paul and everything, states' rights and everything, which is the heart, soul, and flesh of the conservative movement, states' rights, okay? Their power is not in the 10th Amendment. Their power is in the 11th Amendment, because that is what prevents people from suing their own state government, or even suing a part of the state government. You could sue officers, you can't get any money for it. But the type of suit that you bring is very similar to the type of suit Marbury v. Madison was. For instance, Brown v. Board of Education was brought in the matter of an injunction. You could enjoin people for doing unconstitutional acts, officers, you know, but you can't enjoin the state, or you can't sue the state. You can't get money from the state. You could only name the officers. And it's a really crazy thing, because what it comes down to is, like Brennan said when I can't remember what the case was exactly, you know, but he said, okay, well, states aren't people because of the 11th Amendment. And this is a problem that people have in understanding this thing. They're arguing this Occupy Wall Street. They're saying corporations pejoratively. There's nothing wrong with corporations per se. And the issue here with the 11th Amendment is whether a state is a corporation or not. To me, a state is a corporation, but it's a fiction that conservatives have made, that they legislated from the bench, to say that for purposes of the 11th Amendment, a state is not a person. A state is not a corporation. You know, now guys like Scully and Thomas will say, you know, well, we can't allow this because it's a contempt against the state, or it's insinuating the state in some sort of nefarious scheme or something like that. You know, we're humiliating the state. Well, how the hell could you humiliate something that isn't a person? So the whole thing is crazy, and it should just be done away with. But if you look in Blackstone's commentary on the laws of England, you'll see that the idea of overturning acts of Parliament was already contemplated. And it was a similar sort of fiction that were employed by the courts, because if something were contrary to the unwritten Constitution of England, they would say that this is an absurd signification, that Parliament or the king or whatever couldn't possibly have meant this to be, so we can't interpret it that way. And to this day, it's the same way. If something is open to interpretation, if it does not require the strict construction doctrine, which simply means that if fundamental rights are involved, and there's some act of Congress involved or an act of a state, it has to be strictly construed, and the state or federal government has to show a compelling interest of why this provision has to exist, and it has to be strictly construed because it involves abridgment of some fundamental right of the person. So you can't expand it by implication. It's the same idea entirely. And I just wanted to say that, because this is another problem that I see here. Aside from attacking banking, there's this Ron Paul vibe going through here. You know, it's like the states' rights. It's the Jewish merchant leech conspiracy, Thomas Jefferson, the greatest man that ever lived, you know, and all of this stuff. And that's really going in the wrong direction, because all you're doing is you're just feeding back into conservatism, because that's the heart, soul, and flesh and the entire basis of American conservatism. And it all goes back to feudalism and the landed gentry. So it's really the wrong course to take, and that really should be avoided.